Hi there, you're listening to 99.1 FM on CJAM. Welcome back to this week's PBSC Magna Carta.
Magna Carta is a show run by the Pro Bono Students of Canada, Windsor chapter at the University of Windsor's Faculty of Law.
PBSC is on a mission to provide free legal support to people and communities facing barriers to justice. With 22 chapters throughout Canada, we are the largest pro bono organization in the country. Our goal with this program is to provide you all with accessible information about relevant legal issues affecting our community.
Before we begin, I'm your co-host, Clara Bouillonge, a 1L dual JD student. This is my first time working with PBSC, and I am very excited to work with my peers in increasing access to justice for people in the Windsor community.
And I'm your co-host, Sofiya and Clara, a 1L dual JD student at the University of Windsor and Detroit Mercy. This year, I'm excited to work with the PBSC to support our community and the people of Windsor.
Today's episode is all about the Charter of Rights and Freedoms. It's the cornerstone of Canadian law, and in a world that's quickly changing, it's more important than ever to understand your rights.
That's right. Whether it's about freedom of speech, equality, or your right to privacy, the Charter touches every aspect of our lives. So let's dive into what it actually is and why it's so crucial.
By the end of this episode, you'll have a clear understanding of the Charter, how it works, and we'll also look at some recent cases that show up how it's interpreted in real life.
So let's start with the basics. The Charter of Rights and Freedoms is part of Canada's Constitution. It was introduced in 1982 by then Prime Minister Pierre Trudeau. It guarantees fundamental rights and freedoms to every person in Canada.
But it's important to note that the journey to the Charter didn't start in 1982. Canada's earlier Bill of Rights, introduced in 1960 by Prime Minister John Diefenbaker, was a federal law that aimed to protect rights and freedoms. However, it wasn't part of the Constitution, which meant it lacked the legal weight to override other laws.
Exactly. Before 1982, there was no unified set of rights that applied across all of Canada. Provinces had significant control, and there wasn't a consistent way to challenge right violations. Pierre Trudeau's push for the Charter was part of a bigger effort to patriate the Constitution, bringing it fully under Canadian control from Britain.
The Charter became entrenched in the Constitution as a result of the Constitution Act of 1982. This made it extremely difficult to change or override, giving Canadians stronger, more permanent legal protections.
And it also introduced mechanisms like Section 33, the notwithstanding clause, allowing governments to temporarily override certain charter rights, though this has been controversial.
The Charter was a game changer, balancing individual rights with the needs of society, and it set the foundation of modern Canadian democracy. Let's look at some of the key sections of the Charter. One of the most talked about sections is Section 2, which guarantees fundamental freedoms: freedom of expression, freedom of religion, freedom of assembly, and freedom of association.
Freedom of expression is a big one. It's why we can criticize the government, protest, or express unpopular opinions without fear of punishment. But as we said earlier, this freedom isn't unlimited.
Today we're examining R.V. Keekstra, a Supreme Court of Canada case that tackled the complex issue of hate speech.
This case centers on James Keekstra, an Alberta high school teacher who was charged under Section 319.2 of the Criminal Code for willfully promoting hatred against an unidentifiable group. Keekstra communicated anti-Semitic statements to his students, depicting Jewish people with extremely negative stereotypes. He presented these views as facts that students were expected to accept, and he graded them on their ability to repeat them. This was not an isolated incident, but a systemic dissemination of hateful propaganda within the classroom.
So, the case wasn't about a casual remark, but rather a sustained campaign of hate speech.
Exactly. The legal challenge arose when Keekstra argued that Section 319.2 of the Criminal Code violated his rights under the Canadian Charter of Rights and Freedoms.
That brings us to key Charter issues at play. What were the main arguments regarding the Charter breaches in this case?
There were two primary Charter breaches alleged. First, Keekstra argued that Section 319.2 infringed upon his freedom of expression, guaranteed by Section 2B of the Charter. He argued that even hateful speech should be protected under this section. And secondly, he contended that Section 319.3a, which allowed a defense of truth, but placed the onus on the accused to prove it on a balance of probabilities, violated his right to be presumed innocent, as guaranteed by Section 11D of the Charter. This is known as reverse onus provision.
So, the case involved both freedom of speech and the presumption of innocence, two fundamental pillars of our legal system. Let's unpack the freedom of expression argument first. What was the court's reasoning on whether Section 319(2) infringed on the freedom of expression?
The Supreme Court, in a majority decision, acknowledged that Section 319(2) does indeed infringe upon Section 2B of the Charter. The court took a broad view of expression, holding that any activity that conveys or attempts to convey meaning has expressive content, regardless of the message. This means that even hate propaganda, as offensive as it is considered a form of expression.
So, all expression is protected, in some sense, under the Charter.
Yes. The court's view was that all content of expression is protected by Section 2B of the Charter. However, this doesn't mean that all expression is absolutely immune from limitation. Section 1 of the Charter allows for reasonable limits on rights and freedoms, if those limits are justified in a free and democratic society.
That's the crux of the case, really. Did the court find that the infringement of freedom of expression by Section 319(2) was justifiable under Section 1?
Yes, the majority did. The court concluded that the objective of preventing the harm caused by hate propaganda was of sufficient importance to justify overriding the freedom of expression. They recognized the deep harm hate propaganda inflicts on target groups, and the potential for such material to create social tension and violence. The court also pointed to Canada's commitment to equality and multiculturalism as strong reasons to justify the suppression of hate speech.
How did the court view the reverse onus on the accused to prove the truth of their statements?
The court agreed that Section 319.3a infringed upon Section 11D of the Charter, which protects the presumption of innocence. The reverse onus provision essentially required the accused to prove they're innocent, which goes against a fundamental principle of our justice system. However, the majority found that this infringement was also justified under Section 1, as they viewed the defense of truth as a concession to free expression values rather than a requirement under the Charter.
So, the court upheld the constitutionality of both Section 319(2) and 319.3a.
Correct. Despite acknowledging the infringements of Charter rights, the majority of the Supreme Court found that these infringements to be justifiable limits in a free and democratic society. It's important to note, though, that there were dissenting opinions from Justice Sapinka and McLaughlin, who argued that the limitations were not justified. McLaughlin, in particular, felt that the law was overly broad and had a chilling effect on free expression.
What impact did the Keekstra decision have on Canadian society?
Keekstra solidified the legal framework for addressing hate speech in Canada. It made clear that while freedom of expression is a fundamental right, it is not absolute and can be limited to protect vulnerable groups from the harms of hate propaganda. The decision emphasized the importance of multiculturalism and equality in Canadian society, and acknowledged that hate speech is a real and serious problem which can have a detrimental effect on the community and individuals. It also highlighted the unique approach Canada takes to freedom of expression, which differs from the United States.
It seems like a very important case for defining the boundaries of free speech in Canada.
Absolutely. Keekstra remains a critical reference point in debates about freedom of expression, hate speech, and the role of the state in protecting minority groups. It established that Parliament has a legitimate role to play in restricting the dissemination of hate propaganda through criminal law.
Another key section is Section 15, which guarantees equality rights. It's all about preventing discrimination based on things like race, gender, disability, or age.
A landmark case here is Andrews v. Law Society of British Columbia from 1989. Mark Andrews, a British citizen, challenged a rule requiring Canadian citizenship to practice law in British Columbia. The Supreme Court found that this rule violated Section 15 because it discriminated against non-citizens. Let's start with the basics. Can you outline the facts?
Of course. The case revolves around Mark David Andrews, a British subject and permanent resident of Canada, who had met all the requirements to be admitted to the British Columbia Bar, except for one, Canadian citizenship. At the time, the Barristers and Solicitors Act of British Columbia required Canadian citizenship for admission to the bar. Andrews challenged this requirement, arguing that it violated Section 15.1 of the Canadian Charter of Rights and Freedoms, which guarantees equality before and under the law. Gorl Elizabeth Kinnersley, an American citizen and permanent resident, was added as a co-respondent.
So the core issue was the citizenship requirement for lawyers. What was the Law Society's argument for this requirement?
The Law Society essentially argued that citizenship ensures familiarity with Canadian institutional and customs and demonstrates a commitment to Canadian society. They also contended that lawyers play an important role in the administration of justice and the governmental processes of the country, and therefore should be citizens. They argued that the citizenship requirement was a reasonable way to ensure that lawyers uphold their public duties.
And how did the case proceed through the courts?
So the case first went to the Supreme Court of British Columbia, where the trial judge dismissed Andrews' claim. The judge found that citizenship is a relevant personal characteristics for lawyers because it involves a commitment to the community. The case was then appealed, where the British Columbia Court of Appeal overturned that decision, finding the citizenship requirement discriminatory. The Law Society appealed that decision to the Supreme Court of Canada.
This is where it gets interesting. The Supreme Court of Canada delivered a split decision. Can you walk us through the majority and dissenting opinions?
Certainly. The majority, led by Justice Wilson, found that the citizenship requirement did violate Section 15.1 of the Charter. They established that Section 15.1 provides a guarantee of equality before and under the law, including equal protection and benefit without discrimination. They argued that the citizenship requirement created a distinction based on a personal characteristic, which has a discriminatory effect on non-citizens. The majority held that non-citizens, especially permanent residents, are a discrete and insular minority who lack political power and are vulnerable to having their interests overlooked. They also stated that Section 15 covers not only the enumerated grounds for discrimination, but also analogous grounds such as citizenship status. The court established that discrimination is a distinction based on personal characteristics, whether intentional or not, that imposes disadvantages or limits access to opportunities. They noted that the approach in Human Rights Act was applicable to questions of discrimination under Section 15.1. The majority then analyzed the citizenship requirement under Section 1 of the Charter, which allows for reasonable limits on charter rights if those limits are demonstrably justified in a free and democratic society. They concluded that the citizenship requirement failed the proportionality test under Section 1. The court determined that the objective of ensuring familiarity with Canadian institutions, commitment to Canadian society, and competent performance of lawyers was not sufficiently pressing and substantial to warrant limiting equality rights. The court also found that citizenship does not guarantee these objectives, and the less restrictive means were available to achieve these goals. For example, the court noted that it was already the case that those who were foreign-trained lawyers were already required to meet educational requirements.
So the majority said the law was discriminatory, and the discrimination wasn't justified. What about the dissent?
Yes. Justices McKinstry and Lammer dissented, arguing that the citizenship requirement was a reasonable and substantial limit under Section 1. They recognized that Section 15.1 was infringed by the citizenship requirement, but that the legal professions important to the government of the country justified the limitation. They saw the role of lawyers as being fundamental to the administration of justice and the governmental processes. The dissent argued that because lawyers have powers not permitted to other professionals, such as issuing subpoenas, a citizenship requirement is not unreasonable. They also argued that this requirement is a reasonable step to ensure those who become lawyers have a commitment to the country.
What about the concept of similarly situated? Was that discussed in the case?
Yes, that's a very important point. The similarly situated should be similarly treated concept was debated at length and is actually taken from Aristotle's principle of formal equality. The court determined this was not a sufficient approach for Section 15.1 of the Charter. The court found that the similarly situated test was flawed because it didn't consider the content of the law and could justify discrimination laws like the Nuremberg laws. The court made clear that simply because a law applies equally to those it applies to does not mean that it cannot be discriminatory. The court decided a focus on the impact of the law on the individual was necessary.
So, the Supreme Court ruled in favor of Andrews and Kinnersley by a majority decision. What was the impact of this decision?
Oh, the impact was substantial. The most immediate effect was that the citizenship requirement for admission to the bar in British Columbia was struck down. But more importantly, it had a few broader implications. So it clarified the scope of Section 15 of the Charter as applying to non-citizens who are permanent residents of Canada. It also affirmed that Section 15 protects against discrimination based on analogous grounds, not just the enumerated grounds. The court determined that the enumerated grounds reflected the most common bases of discrimination and should receive particular attention. It established a two-step approach to charter challenges. First, does the law infringe on a protected right, such as equality? And then if it does, is the infringement justified under Section 1? It also emphasized that not all distinctions are discriminatory. A finding of discrimination under Section 15.1 requires an examination of whether the law imposes burdens, obligations, or disadvantages on a group not imposed on others, or limits access to opportunities and benefits. It confirmed that the onus to justify an infringement lies with the state, and finally, the decision has been a powerful precedent in other cases involving discrimination against non-citizens and other groups.
So, this case has a long-lasting legacy. What are some of the ways we continue to see the impact of this decision today?
The Andrews case is still a foundational case for equality rights in Canada. It has been cited in numerous cases involving discrimination claims and the interpretation of Section 15. The courts have since expanded its protection to other minority groups. The two-step approach for analyzing charter cases is a standard practice now for courts. It has also impacted the way the legal profession understands and practices diversity and inclusion. It has reinforced the idea that Canada is a diverse and inclusive society where everyone, regardless of their citizenship status, deserves to be and equally. And finally, the case emphasizes the importance of looking at the effect or impact of a law and is used by courts to consider systemic discrimination.
It's clear that Andrews v. Law Society of British Columbia is a crucial part of Canada's legal history. Any final thoughts on this case?
Yes. I do think it's important to remember that the case demonstrates that equality is not a simple or static concept. It requires constant vigilance and a willingness to challenge laws and practices that perpetuate unfairness and discrimination. The Andrews case reminds us that the Charter exists to protect the rights of everyone, including those who may be considered outsiders. It also emphasizes that the limitations to these rights under Section 1 are not to be taken lightly. This decision continues to be relevant as we strive for a more just and equitable society.
Okay, then there's Section 7, which guarantees the right to life, liberty, and security of the person. This section has been pivotal in cases involving assisted dying and abortion rights.
A key example is Carter in Canada in 2015, where the Supreme Court struck down the ban on medically assisted dying. The court found that the ban violated Section 7 because it forced individuals to endure intolerable suffering against their will.
This case is so significant, not just for legal principles involved, but also for its profound impact on Canadian society. So let's dive right in, shall we?
Let's do it. So for our listeners, Carter in Canada, decided by the Supreme Court of Canada in 2015, essentially dealt with the constitutionality of the laws prohibiting physician-assisted death.
Exactly. Before Carter, the criminal code had two key provisions that effectively banned any form of assisted dying. Section 14, which states that no person can consent to have death inflicted on them, and Section 241B, which made it a crime to aid or abet someone in committing suicide.
And these provisions were challenged by a group of plaintiffs, right?
Yes. The main appellants were Lee Carter, Hollis Johnson, and the British Columbia Civil Liberties Association, who were joined by Gloria Taylor, who was diagnosed with ALS. Carter and Johnson assisted Kay Carter, Lee's mother, to travel to Switzerland for an assisted suicide. Gloria Taylor, diagnosed with ALS, also wanted the right to seek physician-assisted death in Canada. They argued these laws violated their rights.
So what were their main arguments?
Their argument was primarily based on Section 7 of the Canadian Charter of Rights and Freedoms, which guarantees the right to life, liberty, and security of the person, and that these rights are infringed upon by preventing access to physician-assisted dying. They also raised an argument under Section 15 relating to equality rights, specifically that people with disabilities face discrimination if they cannot seek physician-assisted dying.
It's interesting. And how did the case play out in the lower courts?
It began in the British Columbia Supreme Court, where the trial judge agreed with the plaintiffs. She found that the laws infringed on the Section 7 rights of competent adults with grievous and irremediable medical conditions who want to end their lives with a physician's assistance. The judge also concluded it wasn't justified under Section 1 of the Charter. She provided Taylor with a constitutional exemption and a 1-year suspension of the Declaration of Invalidity.
So, a win for the plaintiffs at the trial level.
Yes, but that win was short-lived. The British Columbia Court of Appeals overturned that decision, ruling that the trial judge was bound by a previous Supreme Court ruling called Rodriguez in British Columbia. In that case, the court upheld the prohibition on assisted suicide.
Right. The principle of stare decisis, where lower courts are generally bound by higher court precedents.
Exactly. But the dissenting judge in the Court of Appeals disagreed, saying that the trial judge was correct in revisiting Rodriguez. So ultimately, it ended up at the Supreme Court of Canada.
Okay, so what did the Supreme Court decide?
The Supreme Court of Canada unanimously allowed the appeal. They held that the criminal code provisions prohibiting physician-assisted death did indeed violate Section 7 of the Charter, and that these violations were not justified under Section 1.
I mean, this sounds like a pretty big deal. So what were their main reasons for this decision?
Okay. First, the court determined that the trial judge was not bound by the Rodriguez precedent because there was new legal issues that emerged, as well as a significant change in social and factual landscape since Rodriguez. The court emphasized that the understanding of Section 7 had changed significantly since the Rodriguez case. In particular, the legal concept of overbreadth and gross disproportionality had developed since that time, and were not fully considered in the Rodriguez case.
So how did that play into their decision?
The court found that the absolute prohibition was overbroad. In other words, it applied to situations where it was not actually achieving its aim of protecting vulnerable individuals from coercion or being induced to commit suicide. It swept too broadly and included people who were not vulnerable and who had a clear and informed wish to end their lives.
So what about the argument that it infringed upon a person's right to life, as was argued in the dissenting opinion in the BCCA?
So the court clarified that the right to life is engaged when a person or state action imposes death or an increased risk of death on a person, either directly or indirectly. They found that by forcing people to take their own lives prematurely, the prohibition did infringe on some individuals' right to life. But they also said the concerns around autonomy and dignity are also protected by the right to liberty and security of the person.
So, by preventing a competent adult from making choices about the end of their life, the state was infringing their liberty and security?
Exactly. The court pointed out that an individual's response to a grievous and irremediable medical condition is a matter critical to their dignity and autonomy, and that the law already allows people to refuse life-sustaining treatments or request palliative sedation. But denying the right to a physician-assisted death was not consistent with patient autonomy.
So how did the court deal with the government's argument to maintain the prohibition?
The government tried to justify the prohibition under Section 1 of the Charter, which allows for reasonable limits on rights. They said that the prohibition was needed to protect vulnerable people. The court acknowledged that this was a pressing and substantial objective. Prohibiting an activity that poses risks is rationally connected to curtailing those risks. However, the court found the prohibition was not minimally impairing. They were not convinced that a blanket ban was the least restrictive way to achieve the goal of protecting the vulnerable.
So the court didn't agree that it was necessary to ban it outright in order to protect vulnerable people.
That's right. The court reviewed extensive evidence and said that a properly designed and administered regulatory regime with safeguards could protect vulnerable people from abuse and errors. They cited evidence from other jurisdictions where assisted dying was legal and found that the risks could be substantially minimized with proper safeguards.
Well, that was a lot of information for now. Let's take a quick break, hear from our sponsors, and we'll be right back shortly. All right, welcome back. We left off where the court reviewed extensive evidence. So that was really fascinating. What was the final result?
So the court declared that Sections 14 and 241B of the Criminal Code unconstitutional to the extent that they prohibit physician-assisted death for competent adults with a grievous and irremediable medical condition causing enduring and intolerable suffering. They suspended this declaration of invalidity for 12 months to allow Parliament to create a new legal framework.
Which resulted in the new legislation that we have now. That's right.
Exactly. The federal government passed legislation in 2016, now called Medical Assistance in Dying, or MAID, which permits eligible adults to access physician-assisted death. It has been amended a few times since then, broadening its scope, which as we can imagine, is still quite controversial.
So, how has this decision impacted Canadian society?
It has had a huge impact. Carter essentially shifted the conversation around end-of-life care. It affirmed that a person's autonomy and dignity are essential considerations when dealing with end-of-life decisions. It recognizes the idea that a life of severe and intolerable suffering isn't necessarily a life worth living, which is a very sensitive topic.
Of course. And it really brought a number of difficult issues to the forefront of public consciousness.
Absolutely. Before Carter, many people felt that they had no control over how they would die, which led to significant fear and anxiety, particularly for those with terminal illnesses. This case highlights the crucial choice people were facing, either taking their own lives prematurely or suffering until death.
And now, at least for those who meet the criteria, there's another option, which offers some peace of mind.
Yes, but the debate isn't over. There are still many concerns around how MAID is administered, especially around the expansion of eligibility for those with mental disorders. There is a very real need for ongoing discussions and policy adjustments to ensure MAID is safe and accessible while protecting vulnerable people. There are also significant issues around the lack of access to MAID, especially in rural communities.
So, this case is significant both legally and socially, but why is it so relevant to us as law students?
Carter is really relevant because it highlights many key concepts. It's a great example of how the Charter can be used to challenge laws that don't protect fundamental rights. The court's detailed analysis of Section 7, the principles of fundamental justice, and Section 1 are very important for our understanding of Charter litigation.
Definitely. It also demonstrates the importance of stare decisis, and when it's appropriate to revisit previous decisions. The court's willingness to depart from Rodriguez shows that the law is not static and must evolve alongside social values and new evidence.
It also makes us consider the importance of social context in legal decision-making. The court took into account the legislative changes in other countries and the growing body of evidence around end-of-life care.
It also shows us the complexity of dealing with cases involving deeply held moral beliefs. There are very strong arguments on both sides, and the court had to balance these competing interests carefully.
That's right. It also makes it really clear the role of the court to make sure the law upholds the rights of all individuals, including minority or marginalized groups.
Absolutely. It's a case that teaches us the law isn't just about statutes, it's about people and their lives.
Exactly. It shows us how the law has the power to change society for the better, but also needs to be constantly examined and updated.
So let's briefly touch upon the costs awarded in this case.
Good point, Clara. The court awarded the plaintiffs special costs on a full indemnity basis. This means that they were able to recover almost all of their legal expenses. This is not standard practice, but the court noted that this was an exceptional case that involved a high degree of public interest. And these costs can be awarded when the case transcends individual interest and can be demonstrated to be something that is beneficial for society.
And then the case of the Attorney General of BC was also required to pay 10% of the costs.
Yes, because they played an active role in the trial. This was also somewhat unusual, but the judge reasoned that where an attorney general acts more like a party, then they may be responsible for the costs.
See, this is important to understand that the justice system has processes in place to ensure that individuals have access to courts to bring cases that advance justice for all individuals.
Absolutely. Carter in Canada is a landmark decision that recognized the importance of autonomy and dignity in end-of-life decisions.
It's a case that continues to shape our understandings of fundamental rights and is a really important example of how the Charter can protect vulnerable people.
And it's a reminder that the law is living, an evolving thing that responds to the needs and values of society.
Let's shift gears and talk about some recent cases that show how the Charter is applied today. One major case is R.N. Jarvis in 2019.
This case dealt with the criminal offense of voyeurism, but more importantly, it clarified what a reasonable expectation of privacy means, especially in public or semi-public spaces like schools.
Exactly. Before we go into the legal analysis, let's start with the facts of the case.
So, the accused, Ryan Jarvis, was a high school English teacher who used a hidden camera disguised as a pen to secretly record female students at school.
These recordings focus mainly on the students' faces, upper bodies, and in particular, their breasts. The students had no idea they were being filmed, and there was a school policy prohibiting this kind of conduct.
He was charged under Section 162(1) of the Criminal Code, which criminalizes voyeurism when it involves a reasonable expectation of privacy. But here's where things got complicated. What exactly counts as a reasonable expectation of privacy in a school setting?
The trial judge agreed that the students had a reasonable expectation of privacy, but found Jarvis not guilty because he wasn't convinced beyond a reasonable doubt that the videos were recorded for a sexual purpose.
The Court of Appeal was split. They unanimously agreed that the recordings were made for a sexual purpose, but a majority ruled that the students didn't have a reasonable expectation of privacy, leading to Jarvis's acquittal. The Crown then appealed to the Supreme Court.
The big question before the Supreme Court was, did the students have a reasonable expectation of privacy while they were recorded in common areas of their school?
And the Supreme Court's answer? A resounding yes. The court ruled that the students did have a reasonable expectation of privacy, even though they were in a public or semi-public space.
Chief Justice Wagner, writing for the majority, explained that privacy isn't an all-or-nothing concept. Just because someone is in public doesn't mean they expect to be recorded in a way that objectifies them, especially by someone in a position of trust, like a teacher.
The court also laid out several factors to determine whether a reasonable expectation of privacy exists, including the location of where the recording took place, the method of recording, the nature of the relationship between the individuals involved, the focus of the recording, especially if it is targeted at intimate areas, the presence of any policies or regulations regarding privacy, the degree of control individuals have over their personal information in the given environment, and the societal norm and ethical expectations regarding privacy in that particular setting.
The court rejected the argument that students lose their privacy expectations simply by being in a public setting. It emphasized that schools are unique environments where students should feel safe from inappropriate surveillance.
The decision overturned the Court of Appeals ruling and entered a conviction against Jarvis, making it clear that privacy rights can extend beyond traditional private spaces.
This ruling also reinforced how privacy laws intersect with evolving technology. With the rise of hidden cameras and digital surveillance, courts must consider how technological advancements impact individual rights.
A key takeaway from R and Jarvis is that privacy laws need to adapt to new threats. Hidden cameras, AI surveillance, and facial recognition software present challenges that weren't envisioned when earlier privacy laws were written.
Another legal impact is how this case influences the interpretation of Section 8 of the Canadian Charter of Rights and Freedoms, which protects against unreasonable search and seizure. The decision in Jarvis strengthens the argument that privacy protections extend to more than just traditionally private spaces.
It also sets a precedent for how courts define a sexual purpose in voyeurism cases. This will likely influence future cases involving digital and non-consensual recordings.
In addition, this ruling encourages stricter policies in educational and workplace environments, ensuring better protection against hidden surveillance. Organizations must now reconsider how privacy policies are structured to align with this decision.
Beyond the legal realm, this decision has significant cultural and societal implications. It emphasizes that ethical concerns must be factored into legal frameworks regarding privacy and personal autonomy.
It also highlights the importance of consent when it comes to recording individuals. Many provinces have since reviewed and updated their privacy laws inspired by this ruling to address growing concerns over digital surveillance and hidden cameras.
Another key takeaway is how this ruling protects vulnerable individuals. Women and children and marginalized communities are often disproportionately affected by voyeuristic crimes, and this decision helps reinforce their legal protection.
The case has also had an impact internationally, influencing discussions in other legal systems about privacy in semi-public places. Many jurisdictions are looking to Canada's ruling as they update their own voyeurism and privacy laws.
In practical terms, businesses, schools, and public institutions are now more mindful of how surveillance technology is used. More people are questioning whether they are being watched without their knowledge, leading to greater advocacy for transparency in surveillance practices.
You might ask yourself, why should we still care about R and Jarvis today? Well, in an age of iPhones, social media, and AI-driven surveillance, the balance between public visibility and personal privacy is much more crucial than ever.
This case acts as a safeguard against inappropriate surveillance and ensures that individuals, especially vulnerable groups like students, are being protected from being objectified and exploited through technology.
It's also influencing how organizations shape their privacy policies. Many schools, workplaces, and institutions are now revisiting their regulations to ensure they align with modern privacy expectations.
The decision sets a high standard for consent and inappropriate recording practices, which is crucial as we navigate new challenges in digital privacy. It reminds us that privacy is a fundamental right, even in settings that aren't traditionally considered private.
R and Jarvis isn't just a case about one teacher's misconduct. It's a crucial precedent that has shaped privacy expectations and digital rights in Canada.
Absolutely. And with technology advancing rapidly, the principles from this case will likely continue to influence future privacy and surveillance laws.
So another recent case is Ward in Quebec in 2021, which involved freedom of expression under Section 2. Comedian Mike Ward made controversial jokes about a disabled child. The Supreme Court had to decide whether these jokes crossed a line into discrimination. Let's start with the facts. So what exactly happened in this case, Sofiya?
Okay, so the case revolves around a comedian named Mike Ward and a young man named Jeremy Gabriel. Jeremy Gabriel was a public figure with teacher's Collins syndrome, a condition that caused certain malformations of the head and deafness. He had an artistic career as a singer starting at a young age. Mike Ward, in his comedy routines, made jokes about Gabriel, mocking his physical characteristics and his career.
And how did this lead to the legal battle?
Gabriel's parents filed a complaint with the Commission des droits de la personne et les droits de la jeunesse, arguing that Ward's comments were discriminatory and violated Gabriel's right to dignity. They claimed that Ward's comments constituted discrimination under the Quebec Charter, specifically violating Sections 4 and 10. The Human Rights Tribunal sided with Gabriel, ordering Ward to pay damages. That decision was appealed, eventually making its way to the Supreme Court of Canada.
Okay, so the core of the case is about balancing two important rights. First is the right to dignity, and the second is the freedom of expression. Can you explain how these rights are protected by the charters?
Certainly. In this case, we're dealing with the Quebec Charter of Human Rights and Freedoms. Section 4 of the Quebec Charter protects every person's right to the safeguard of their dignity, honor, and reputation. Section 10 of the Quebec Charter, which is the equality provision, protects against discriminatory interferences with any of the rights or freedoms set out in the Quebec Charter. Additionally, Section 3 of the Quebec Charter guarantees fundamental freedoms, including freedom of expression. The case also makes reference to the Canadian Charter of Rights and Freedoms, but the primary analysis is done using the Quebec Charter.
Okay, I got it. It sounds like the Supreme Court had to decide how to balance these rights when they come into conflict. So what did the majority, Chief Justice Wagner and Justice Cote, decide?
The majority framed the legal issue as determining the proper legal framework to assess a discrimination claim in a context involving freedom of expression. They emphasized that a discrimination claim is not the same as a defamation claim. They established a three-part test for proving discrimination under Section 10 of the Quebec Charter. First, a claimant must prove a distinction, exclusion, or preference, which means they were treated differently. Second, that distinction must be based on one of the prohibited grounds listed in Section 10, such as disability. Third, the claimant has to prove that the differential treatment impairs the full and equal recognition of a right or freedom guaranteed by the Charter, in this case, the right to dignity. The majority then focused on the interaction between the right to dignity and freedom of expression, applying the principles from Saskatchewan's Human Rights Commission v. Whatcott, which dealt with hate speech. They said that, in this context, a complainant must demonstrate that the expression incites others to vilify or detest the targeted person on a prohibited ground of discrimination, and is likely to lead to discriminatory treatment of the person.
And how did the majority apply this test to Mike Ward's comedy?
So, the majority found that while Ward did target Gabriel, that distinction was not based on his disability. They noted that the Human Rights Tribunal had specifically found that Ward targeted Gabriel because he was a public figure, not because he was disabled. Additionally, the majority concluded that Ward's comments within the context of his comedy routine did not incite others to vilify Gabriel, nor were they likely to lead to discriminatory treatment of Gabriel. They noted that hurtful expression alone is not enough to constitute discrimination. They emphasized the importance of considering expression in context.
So, according to the majority, the comments did not meet the threshold for discriminatory speech under the Quebec Charter. So it sounds like their reasoning was heavily influenced by the Whatcott case. What was the dissenting opinion, led by Justices Abella and Kasser?
The dissent strongly disagreed with the majority's findings, highlighting that while the majority viewed Ward's comments as not based on a prohibited ground, the dissent stated that Ward targeted aspects of Gabriel's public personality that were inseparable from his disability. The dissent said that this was a key issue that indicated that the comments were discriminatory based on a prohibited ground.
It sounds like the dissent focused more on the impact of the comments on Gabriel rather than the intention of the speaker.
Exactly. The dissenting judges emphasized that the impact of the conduct, not the intent, is what matters. They argued that the majority was incorrect in not recognizing this. The dissent was also noted that freedom of expression does not include the right to discriminate. Moreover, the dissent states that it is also not acceptable to discriminate if it results from treating others alike.
And what did the dissenting judges say about the application of Sections 9.1 of the Quebec Charter?
So, the dissent argued that the majority should have considered the balancing of rights under Section 9.1 before finding no prima facie discrimination. This section considers democratic values, public order, and the general well-being of citizens when balancing rights. The dissenting judges believed that freedom of expression acts as an internal limit to the right to dignity rather than being a justification or defense to a discrimination claim. They emphasized that the fact that Gabriel was a child at the time of the comments was particularly relevant.
So, to be clear, they saw Gabriel's vulnerability as a key factor in the analysis.
Yes, absolutely. The dissent pointed out that the comments were wildly disseminated, meaning Gabriel couldn't escape their impact. They argued that Ward's jokes implied that society would be better off if Gabriel were dead, and that they invoked archaic attitudes of advocating the exclusion of children with disabilities. They said that these were the types of comments that caused severe harm. They concluded that the jokes did not just target the person, but that they amounted to dehumanizing and humiliating a disabled child. They said violated Section 10 of the Quebec Charter.
Those two opinions really showcase very different ideas about when speech can be considered discriminatory. What did the dissent say about the application of the Whatcott case?
The dissent argued that the majority was incorrect to apply the Whatcott framework, saying that the purpose of the provision in that case was different from the purpose of Section 10 of the Quebec Charter. They note that in Whatcott, the provision was aimed at preventing societal harm by preventing the causes of discriminatory activities. In this case, they argued Section 10 is inherently tied to the other individual human rights and freedoms, and is meant to address individual harm. The dissent noted that neither the Canadian Charter nor the Quebec Charter make hate speech the threshold at which discriminatory comments are actionable.
So, according to the dissent, the standard for discriminatory speech should be lower than hate speech when it causes individual harm. What are some of the significant differences in legal reasoning?
So, there are a few key differences. The majority focused on protecting freedom of expression and establishing a high threshold for when speech is considered discriminatory. They wanted to make sure that discrimination claims do not stifle speech or expression that is simply offensive. The dissent, on the other hand, focused on the protection of vulnerable individuals and emphasized the harm that Ward's comments caused, as well as the systemic issues that they might indicate. They were more willing to consider the comments discriminatory due to their nature and the vulnerability of the victim, and placed much more emphasis on the impact of the conduct rather than the intent.
It's clear that both sides saw the importance of different values. So what is the overall impact of this case?
Ward v. Quebec is really important because it clarifies how we balance freedom of expression with human dignity, especially when it involves discriminatory speech. the Supreme Court reinforced that freedom of expression is a fundamental value, but that it is not absolute. The ruling establishes a test for discriminatory speech under the Quebec Charter. The ruling makes clear that the effects of the speech on third parties are key, and the discrimination claims must be limited to expression with truly discriminatory effects, rather than just hurtful expression. It also underscores the importance of context when assessing comments, and whether or not comments meet the threshold for discriminatory speech.
It sounds like this case leaves a lot to consider for future cases that will need to balance human dignity and freedom of expression.
Absolutely. Ward v. Quebec is a reminder to be mindful of our words and actions, especially when vulnerable individuals or groups are concerned. Together, these cases remind us that the Charter is a living document. It evolves with society, addressing new challenges and balancing competing rights in an ever-changing world.
All right, so that's a wrap on today's episode of PBSC Magna Carta. We've explored the history of the Charter, broken down some of its key sections, and looked at how it's being applied in modern cases.
The Charter isn't just a legal document. It's a reflection of our values as a society, and understanding it is essential for every Canadian.
We hope this episode has helped you see why the Charter matters and how it impacts your life. If you're located in Windsor, Ontario, or anywhere in Canada and need help understanding your rights, here are some resources. Legal Aid Ontario provides legal services for those who qualify based on income. Community Legal Aid in Windsor is a clinic run by the University of Windsor that offers legal assistance to eligible individuals. The Canadian Civil Liberties Association advocates for the protection of fundamental freedoms and human rights. The Ontario Human Rights Commission, so if you believe your equality rights have been violated, this is a great place to start. And the Supreme Court of Canada Decision Database, if you want to read more about the cases we discussed today.
Remember, knowing your rights is the first step in protecting them. Thanks for listening, and remember, knowledge is power. See you next time on Magna Carta.